The Honorable Justice Belinda Ang, Chair of the Board of Directors for Singapore Mediation Lecture, Dr. Orsolya Székely, Head of Dispute Resolution Service at the World Bank, distinguished guests, ladies and gentlemen, let me extend a very warm welcome to you to the Singapore Mediation Lecture and Appreciation Lunch 2025. My name is Henry Heng. I'm the Managing Director of Terra Law LLC. I see I have a fan in the audience. I'm also a mediator with the Singapore Mediation Center, as well as a coach and assessor. I'll be your MC for today. The Singapore Mediation Lecture was established 14 years ago to promote mediation as a vital tool for conflict resolution. Over the years, this annual lecture has brought together leading experts, practitioners, and thought leaders from around the world to share their insights and experiences. The lectures also serve as a platform for the exchange of ideas, the development of new approaches, and the strengthening of mediation practices both locally and internationally. Following the lecture, we will host the Appreciation Lunch to honor the active champions of mediation and those who have devoted much time and effort to the training of new mediators. In the next hour and a half, we'll hear from our esteemed keynote speaker, Dr. Orsolya Székely from the World Bank, and a panel of experts thereafter. Before we begin, please allow me to explain the QR code on the screen. We would like to invite you to raise questions which you may have during the keynote address or panel discussions. You may either scan the QR code on the screen or log on to the Mentimeter with the access code 61235244. It's on the screen, as you can see. To log on for your questions, we will also flash the QR code again after the keynote address. May I now invite you to welcome Mr. Kevin Quek, Chief Executive of Singapore Mediation Center, to deliver the welcome remarks. Mr. Quek.
The Honorable Justice Belinda Ang, Chairperson of the Singapore Mediation Center, Judges of the Supreme Court of Singapore, members of the Board of Directors of the SMC, Dr. Orsolya Székely, I've been told it's Dr. Székely, Head of Dispute Resolution Service at the World Bank, distinguished guests, ladies and gentlemen. Good morning and a very warm welcome to the Singapore Mediation Lecture and Appreciation Lunch. It is a pleasure to have all of you here with us today, and this year marks the 14th edition of SML, a tradition that has become a cornerstone of SMC's calendar. I would like to thank our sponsor, Aequitas Law LLP, and academia partners, the Singapore Management University, and the Singapore International Dispute Resolution Academy, or SIDRA, for supporting the 14th Singapore Mediation Lecture. This annual gathering serves several meaningful purposes. It is an opportunity for ADR professionals, mediators, adjudicators, members of our SMC training faculty, and our partners from the legal community to come together to share ideas and experiences. It is also a chance for us to express our heartfelt appreciation to those who contribute significantly to the ecosystem, our committee members who devote their time to the development of mediation and adjudication practice, the many law firms and practitioners who work to support the mediation and adjudication movement, particularly through their work with the SMC, and our training faculty. It is this spirit of community, collaboration, and mutual respect that sustains and advances the ADR landscape in Singapore. The past year has been significant for the SMC, marked by meaningful developments across various fronts. As we look ahead, we are committed to building on this progress, not only through new initiatives, but also by strengthening ongoing efforts and deepening our impact. Allow me to highlight some key areas of focus and recent developments. First, advancing access to justice. Beyond community disputes, the SMC also plays an important role in advancing A to J. Some may be unaware that SMC administers a wide range of affordable and timely ADR services in collaboration with several public agencies, including the BCA, IMDA, SkillsFuture Singapore, the Singapore Medical Council, and MOHH. In the past financial year itself, we have administered more than 500 such cases, covering disputes between SMEs, disputes between students and private education institutions, disputes concerning users of healthcare and telecommunication services, just to name a few. These are cases that otherwise might have ended up in court or tribunals, but thanks to our ADR mechanisms, parties can access justice efficiently and affordably. We remain committed to ensuring the sustainability of these such services so that access to justice remains a reality for all segments of society. To that end, we are also in active discussions with several agencies to extend such services to a broader range of users. Another significant development this year is the consolidation of SMC's training and development function under our parent organization, the Singapore Academy of Law. This integration, which took effect last month, enables the seamless incorporation of ADR training into SAL's structured programs and career pathways, particularly for advocates and in-house counsel. This consolidation also brings significant benefits to the wider community of ADR professionals. With SMC's training and development function now integrated under the SAL, our ADR practitioners will benefit from a more seamless and structured learning experience. Moving forward, ADR training will be incorporated into our broader professional development pathways, offering clearer progression and more targeted content aligned with practitioners' roles and responsibilities. The joint SMC-SAL team will curate a streamlined suite of programs that enhances relevance, ensures consistency in quality, and minimizes duplication. Participants can also expect improved logistical support, cost efficiencies, and access to a shared pool of experienced faculty and training resources. Beyond initial training, we also recognize that our mediators and adjudicators must be supported in their professional development. To this end, SMC will roll out structured continuing education programs to ensure that our panelists remain at the forefront of evolving ADR practices. Whether through technical skills training, case-based learning, or exposure to cross-jurisdictional developments, we are committed to supporting a community of practitioners who are well-equipped, knowledgeable, and responsive to the needs of the field. While continuing to invest in access to justice, training integration, and professional development, SMC must and will remain equally committed to our core service, delivering quality ADR services that are responsive, tailored, and effective. A key strength of SMC lies in its diverse panel of mediators and adjudicators who bring expertise across areas such as commercial, construction, and IP disputes. This breadth allows parties and the SMC to appoint mediators or adjudicators best suited to the specific nature of the case. The SMC also takes a dispute-centric approach that emphasizes flexibility and responsiveness. This agility is particularly valuable under Order 5 of the Rules of Court, which extends the duty to consider amicable resolution before commencement and throughout the course of proceedings, including all stages, from early to late or even on appeal. SMC's responsiveness also allows it to support the efficient progression of cases by accommodating parties' mediation requests that are well within the court-directed timelines. Whether the matter is straightforward or complex, SMC remains committed to providing a mediation process that is timely, adaptable, and aligned to all parties involved, to the needs of all parties involved. I move on to the last segment of my opening remarks, and I would like to take a moment to express my sincere thanks to the SMC Organizing Committee led by Karina and Richard for their dedication and hard work in putting together this year's SML. Their efforts have made today's gathering possible and truly meaningful. this point, it is my privilege to introduce our keynote speaker, Dr. Orsolya Székely, Head of Dispute Resolution Service at the World Bank Accountability Mechanism. In 2021, Dr. Székely was given the responsibility of establishing an accountability mechanism at the World Bank that for the first time would include a dispute resolution service, complementing the institution's long-standing compliance-based complaints mechanism. The timeline was ambitious. The goal was to make the dispute resolution functional, operational within a very short period of time. 4 years later, what began as a significant challenge gradually developed into a meaningful addition to the institution's accountability framework. This progress has been supported by Dr. Székely's broad experience across both public and private sectors, which has informed her approach to build a constructive, interest-based process. As we reflect on the progress the SMC has made and consider the road ahead, it is essential to draw both inspiration and insight from global leaders in dispute resolution. Today's lecture offers us an opportunity to do exactly that. Originally trained as a human rights lawyer, Dr. Székely began her career at the European Court of Human Rights. Over the past 2 decades, she has held leadership roles in fragile and conflict-affected countries, helping to establish accountability mechanisms and conduct oversight. Her work with the Council of Europe, European Union, United Nations, and the Organization for Security and Cooperation in Europe has taken her to challenging contexts such as Kosovo, Afghanistan, and Myanmar. Dr. Székely is a recipient of the Oxford Women's Leadership Scholarship and completed her Global Business Diploma from Syed Business School. She is a Harvard-trained negotiator and a mediator accredited by the Center for Effective Dispute Resolution. In her role at the World Bank, she also chaired between 2022 and 2024 the Secretariat of the Independent Accountability Mechanisms Network, which includes 23 accountability mechanisms of international financial institutions. Please join me in welcoming Dr. Székely to deliver the 14th Singapore Mediation Lecture. Dr. Székely, please.
Thank you, Kevin. Thank you for the introduction. I'm very humbled to stand in front of you. This is probably the first time that I can actually speak about the dispute resolution service at the World Bank. So for me, it's a very exciting moment. And it's exciting because not only for 3 years, I don't think we looked up even from what we were supposed to do. We were just grinding and doing our jobs. But also because, as you know, almost everything is confidential in what we do in dispute resolution. So how can we speak for it? But today I'm standing here and we have 2 cases concluded. So it's transparently out there in public. I'm lucky to be able to speak about them. But I'm also able to speak about the road that took us here. So maybe there are lessons learned that we can then share among each other. But before I begin, I would like to thank for all of those who made this happen, that we are here today. So I would like to thank the organizers primarily and for this fantastic venue. I would like to thank Ted, my good friend, who thought of me to invite as a speaker. I don't know what you had in mind, but I'm glad to be here today. And I would like to thank the Singapore Mediation Center, Aequitas Law, and Singapore Management University for making this event happen. I think it's an important event today because we are from very different backgrounds. When I asked who is the audience, who am I talking to, I've seen that from judges, academia, students, new mediators aspiring to be, it's a very diverse audience today. So I hope to speak about mediation with the absolute passion that drives us every day to make what we do happen. And I hope that that will, so to say, energize the crowd to then later on ask questions and contribute to the panel discussions. So before I begin, I would normally ask you to introduce yourselves, which I won't do now because I think that would take the 45 minutes in itself. But it would be really useful, I think, if you think back to a moment when you were involved in a conflict. choose any. It can be a construction conflict, investment, family dispute, whatever conflict. I don't want to trigger you, so don't think too hard of the negative effects, but think of the moments when you were entrenched in this conflict, the negative feelings, what you took home, the feelings that this is never going to be peaceful again, all the elements that made you feel just really bad about being in this conflict, and maybe even the hopelessness of ever being resolved. And then think of the moment when solutions were found, when trust was rebuilt, when you felt that peace is coming back and some sort of progress happened because the solutions were found. So you started to open your mind as to now what's the next, what can we do together? And it's that piece why we all do this. Because there are judicial ways to get to outcomes, but it not always provides remedy. I wrote decisions, judgments for 5 years at the European Court of Human Rights, and it was that, so to say, dissatisfaction when I had to meet applicants and tell them, well, this is the outcome, but I know it's not really what you were looking for. So sometimes you need judicial ways, but sometimes you need mediation to really genuinely provide remedy for the people. So I think it's that peace and that outcome which we are looking for whenever we approach mediation and dispute resolution. For the World Bank, this was a long journey. 30 years of compliance investigation at the bank without any possibility for either the borrower or the people to be directly involved in their disputes. And that's a big thing. So a compliance investigation on the other side, you find only management, and you look at whether they complied with the standards which World Bank aspires to achieve in development. And that's great. We would like to have ideally development which has no harm attached to it and doesn't do anything bad, not to mention aspiring doing something really great. But when harm happens, this needs to be addressed. And because in the World Bank context, a public sector entity, sovereign governments did not want anyone to come to their territories. There was no direct involvement. On the other side, it was the bank management who was always at scrutiny whether they complied with the standards. So bringing about the discussions to create the accountability mechanism ground rules, the resolutions in 2020, it took almost 8 years for the bank to get to that stage that they had a ground document. But when they recruited me in 2021, we literally had the ground document and nothing else. So the dispute resolution service was an empty page. We went from that stage within 2 months to establish the dispute resolution service. And the reason was because not only we had to establish the accountability mechanism encompassing an entire process, building compliance and dispute resolution into one process, but also we had to offer it on an equal basis. Why would people choose dispute resolution if compliance has existed for 30 years? Why would we choose an option which is a new element in the process? What's the guarantee that it's going to produce us the outcomes we are looking for? So it was very important that we had operating procedures in place, transparency elements ensured, a dispute resolution with good professionals who can do this, and mediators who are willing to dive into some of the very complex cases which the World Bank was not finding solutions for a long time. So in a way, we worked relentlessly to make this happen. And of course, we were not alone. So having the IFI network of 23 banks, they have had their experiences before, so we could build on those. But at the same time, we were really alone breaking these grounds in the World Bank. To change mentality of an organization like the World Bank is not an easy task. There is a board, there are management functions. Everybody had to be very quickly informed of what we are trying to do and promote a new way of looking at accountability, which is not compliance-based, but problem-solving based. It's a shifting mindset. You know very well when you are in the mode of advocacy, you are arguing for your rights, but when you switch to problem-solving, you literally have to put on a different hat. And that change had to happen organizationally, had to happen within the compliance body, and had to happen within a very new dispute resolution service. Now, some years later, we have had, in almost all cases, DR offered, and we had 6 accepted by the parties. At the beginning, this was not obvious. They thought, why would the government agree to mediate versus a community? And why would a community agree to mediate who felt that the government is much more powerful? So power imbalance in the public sector context is really a great challenge. And now I will talk later on maybe a little bit about how we overcome those. And bear with me if you are not too interested in the details, but I know that there are some mediators out there who are. So I think it's important that we had to take into account all these specifics of the public sector versus the private sector, like in the Singapore context, where sometimes mediation happens within 1 or 2 days or maximum a week. In the public sector context, we have 12, 18 months maximum to be able to conclude the mediation process. So it's a long period of time, very complex issues involved. So we had, I think we have the cases up there. We have a global operation. We cover projects globally. The accountability mechanism addresses harm, which happen in the context of development projects which the bank implements. And all these projects can be anywhere. So you can imagine in a year, it's about 18,000 projects pending. So what's the likelihood of harm being out there? Quite a high chance. What's the likelihood of people speaking up about it? Very little. So we had to have immense outreach through civil society and through other means, including social media, where we simply promote, please reach out to us if you have a problem. But it's also a very powerful mechanism because any 2 requesters can speak up against the World Bank doing harm. So I think this direct access is quite amazing that can be done. People can just simply submit a complaint, and then of course we need to make sure that the complaint is well funded. We have some eligibility criteria to be fulfilled. But nevertheless, once the process enters and they accept dispute resolution, there is an opportunity for these people to directly be involved. Now, any 2 people can submit complaints, but in none of the cases we had 2 people on the other side. So please imagine communities of hundreds and thousands. So how do you conduct mediation when you have so many stakeholders involved? On the other side is the borrower. How do you make sure who is the borrower on the other side? Is it the Ministry of Finance? Is it one particular person? Is it the executive agency? And who is responsible for signatures? So we had to figure out in every context what would be eventually the process that gets us to a signed agreement. So all this works, and I think there are a lot more complexities involved, of course, are part of the preparations we do, with the dispute resolution service being in DC and then mobile teams being decentralized for each case, where we offer the mediators to the parties, but because it's a voluntary process, just like any mediation, they have to agree to who the mediators would be. So we don't select for them. They have to choose who they would like to work with. Once we enter the process of dispute resolution, we start out with promoting signing a dispute resolution framework that addresses the ground rules and what are the issues to be addressed. This is a very important step in the process because we would not engage if these ground rules are not clearly identified and signed by the parties. That's already a commitment. We want to be here. We would like to be part of this process. And afterwards, what happens with management, possibly part of the process as observers, that we try to facilitate a discussion. Now, how does this look like? In every case, we started out with very heavy threats and reprisals. So people don't even talk to each other. How do you start out a mediation where they are not willing to sit to a table? In the first case in Uganda, which don't play at the video, which I'm going to talk about, basically we started in COVID with masks on, but also people not willing to meet. So the first meeting, I did not know where I was going. We were not told the location. We were sitting in a car and we were being taken to some place where allegedly a community was waiting for us. So this was the starting point, and it was not easy, also because of COVID. And imagine, as mediators, your face is covered. How do you create trust? How do you start speaking? How do you communicate? Eyes do matter a lot in this context, but also it's about reassuring the people within a matter of hours that you are here and you can do this. The same way with governments, we are normally received with the welcome of what are you doing here? And then within a matter of hours, we see, okay, we would like to actually engage in this process. So I think this is where our skills are extremely useful, where we have a comparative experience, but also a humbleness to approach every single dispute. It is about the people. It is about what matters to them most. Nobody wants to be in conflict, and we should remember that. It is about understanding what side they come from, why are they there, how did they get there, and why are the positions important to them. And maybe they don't even understand why they are important to them. So we need to start helping that process to move on. So maybe it's time to play the Uganda video so we can just see a concrete example, and then I can talk about it.
In June 2021, the World Bank Inspection Panel received a request for inspection from a local civil society organization in Uganda. The request was made on behalf of community members living near the Lupigi Channel in Kampala. The community members allegedly faced a forced eviction attempt and were rushed through a threatening and coercive resettlement process during preparations for an infrastructure improvement project financed by the World Bank. The complaint was against the Kampala Capital City Authority, or KCCA, the agency responsible for implementing the project. Later that year, after the World Bank's board approved the inspection panel's recommendation to investigate, the parties were offered the option of dispute resolution, and they both agreed to it. This broke new ground, marking the beginning of the World Bank Accountability Mechanism's first ever dispute resolution case.
From the beginning, it was absolutely clear that we had a big job to do.
You come in at a time when people's moods are already on fire.
Waliwo obutali nga KCCA egamba etegenda tusasula wadde omuntu n'omu.
We started at zero.
After 18 months of mediation, a confidential agreement was signed by both parties, addressing many concerns, including involuntary resettlement and acquisition processes. The parties then requested that the Dispute Resolution Service stay on to monitor the implementation of the agreement.
DRS basically provided an environment where these two parties can listen to each other, can talk about the issues freely.
The experience we have gotten as KCCA in this dispute resolution process is a good one. There's a tendency of entities to look at it as sort of a critiquing process and so on. I think from my experience it wasn't. It was an issue of amicably settling issues so that all sides are comfortable where they are, and also reminding us to do what we are obliged to do.
Maybe if the DRS had not come, some of these cases may have ended up in litigation.
okusobola sadi esigala nga ye ekyayiginayo forever naye kati nga wano olwaleero ogenda mu state council ku ssaawa zino balina essanyu nga bakulabye era bakubuuza n'okubuuza kiki ky'oliko ekitayiwe luli.
The communities became part of government actually.
These are very powerful words when, after having been involved with this dispute for 18 months, and it was literally on the last day that they managed to reach an agreement. I remember the moment where they reached an agreement, but they still asked, so what's next? When you are involved in a dispute for 18 months, it becomes your life, it becomes the purpose of everything you do, and then when you finish a conflict and you arrive to the peace, you're wondering, okay, how is my safe space going to be maintained? How is this agreement going to be implemented? And how am I going to get eventually the final settlement achieved? So it took more than a year to implement the agreement. So I just want to project here the complexities of being involved with the World Bank project and the public sector because we literally walked through the entire agreement and the implementation of it. So every compensation was finally paid. And what it takes in the public sector context, it's very often not only each case is a file, so you have to walk through it in terms of what documents it needs, how to complete it, but sometimes to raise compensation and to raise standards, and this is where justice is not lost and accountability is not lost. We don't agree to an agreement which is illegal or which is not up to the standards of the World Bank. You need to have legislative processes often to be able to do those changes. And I think it's important to lean back maybe to the basic principles of DRS, what we are trying to do. First of all, we are trying to promote trust. To do that, you really have to have trust in the process itself. So you have to have right procedures, accountability tools out there, you have to have the right people, you have to have the credibility of those mediators who are there. Even though you are not out there in the public, you must be able to be accountable yourself. So we have set up a system that's able to do that. Then you have to have independence. We report directly to the board. We are not reporting to management or the president of the World Bank, since we have to be fully independent in the sense of what we do, which is why I think it's very reassuring to civil society and people involved that we genuinely go in with a neutral mindset. And yes, it's possible to go in even when power imbalance is there, but we will talk about that later. I think it's also important we have the basic principle of accountability, and not only we are part of the accountability mechanism, but this was a big question of the World Bank. How is accountability ensured in a dispute resolution process? How do we make sure that the standards don't get lost, that they don't agree because of power imbalance to an agreement that's eventually putting someone to a disadvantaged position, but also in a way that we promote the learning and the change in the World Bank that's required, not only within a given case, but across the sectors. And maybe I quote another case in Nepal where a transmission line was stuck being built, 75 towers, 2 of them could not be built, because rightly so, the community complained about the resettlement policy-related matters, compensation, environmental issues, etc. So for 10 years, the tower line could not be completed. And in the context of Nepal, that's millions of people not getting electricity. So in a way, you can see also here the impact of, or the negative impact. Conflict has weight and conflict has a price. So also think about that when you invest in the resolution of a conflict, like creating an accountability service and the dispute resolution service, how much it costs. Well, think about the cost only in the context of Nepal, millions lost a day because something could not be built. So in a way, I think it's important to put the context in there that you really have to be able to explain this to the bank as well, what the problem solving really means, is that learning that in the case of Nepal, the outcome, not only the case was settled and it was an outcome that the towers could be built, millions of people got electricity, the community was compensated, but the actual result was also that another project negotiation at the same board started to move again, a hydropower project which was until then stuck. Investment started to flow in, cross-border electricity could be transported, etc. So the impact is immense. And I would like to draw back that, again, it's always about the people. So we can think of this impact, and this impact is generally the rush on the government side to get things implemented and get development going, is the rush on the World Bank side to finance the project and to do things in a way that things move quickly. But it cannot be rushed, so those 12 months, 18 months had to be invested not to be involved in a 10-year-long conflict. So in a way, we are also trying to promote now, as we look forward in the World Bank, that it would be really useful to bring in dispute resolution as early as possible. Do not wait 10 years and give us a conflict that's almost impossible to settle. try to think of a system that brings in dispute resolution early, even before a compliance process, but not only early in that sense, but early when you design a project, for example. We have the possibility to address potential harm. We don't need to wait for the harm to happen. And it's a very useful tool to think about it that way. There's another conclusion or lesson learned maybe within the bank that they need to consider. When you think of investments and in the bank context, it's usually all about risks. So conflict is risk. I see conflict as an opportunity because when you settle a conflict, then development happens and new possibilities rise. But if you think about it as a risk, you almost immediately title a project high risk. Did that solve the conflict you're trying to avoid? No, it did not. And I think it's important to consider that when we work in an increasingly fragile and conflict-prone world, as we are doing so today, it's important to recognize that conflicts need to be addressed as early as possible. So moving on, maybe just to, and I've switched around, moving on to the next, how can we think about the future? And in that sense, the Singapore's role in global mediation is immense, not only because the Singapore Convention put mediation to the global map, but also because you are a hub where all these exchanges and knowledge exchanges can happen. And I really hope that we can build on this because I believe in the power of networks, hence I chair the accountability mechanism network itself. Networks have the potential to grow and to promote what we really need to is this trust and accountability which we are providing also in mediation. So moving forward, I hope we can think about the future in a way that there are plenty of challenges ahead, plenty of conflicts out there, not only in the World Bank context, but way beyond. What is it that we can do to promote better understanding of those, even better tools? I look forward to hearing about the AI tools on Friday when I meet the colleagues, because I think as we move forward and having been through very complex mediation contexts, we must use some technology out there to be able to process quicker and better the information we receive while maintaining, for example, data and privacy in the context which we work in. Also, I think it's important that we recognize that having dispute resolution is not an alternative to having a judicial process. So I hope today at the panel we will speak about the two coexisting. At the World Bank, I was asked a lot at the beginning, but are you trying now to take away cases from compliance? And I don't think that's the right way to look at things, right? There is a reason why people agree to a voluntary process of dispute resolution. They should have the possibility to do so. But it doesn't mean that there aren't judicial ways where we need to accept and agree that justice can happen through a decision of a court. So I think it's important that how we coexist, we can discuss later on, is an important element of our work, and also to recognize that not every mediation is legally led, because I think there are lots of mediators out there who are not lawyers, fantastic mediators, and it's good that we have that varied expertise which we bring to the table when people need to settle their disputes. I should be getting to my final reflection. The notes remind me. So I think it's important that we relate back to why we are in this and the trust and the peace I asked you to say at the beginning. Because when we get started with dispute resolution, it's very easy to get entrenched in the nuances and the details of a conflict. But eventually the outcome is about better development for the bank and better lives for the people the bank is trying to help. And how we get there, I think, is important to see that dispute resolution is part of the development. Why we want to be an independent mechanism, and we would like to make sure that people understand that it's standing outside of management. We cannot do anything without that knowledge going back to the bank and them learning from it. So I have an additional challenge of making that happen at the bank via the board and discussions with management. But it was amazing to see the progress from moving to we have to force this to we can do this and we want to do this and we voluntarily want to do this. And I think it's literally that mind shift that you can achieve through problem solving and discussions, through understanding the other, through trying to see how to do things better. I don't know how long I have been speaking. I didn't look at the time. But I think it's, I will try to close around here because I really look forward to having the panel discussion today. And if you do have any questions, please do ask through the Metrimeter. Ideally, this should be a conversation with all of you. And I really look forward to hearing your opinion about things. Thank you so much for your time.
Thank you, Dr. Székely, for your most insightful lecture. We'll now move to the next segment, which is the panel discussion. I think we got to wait a little moment for the staff to bring the chairs up. Let me introduce our moderator for the panel discussion. He's none other than Mr. Lim Tat. He's the managing partner of Aequitas Law LLP. Tat is the chair of the International Mediation Institute, the Society of Mediation Professionals, a director on the board of the SMC, and a principal mediator with over 20 years of dispute resolution experience. He's recognized by Lexology Index as a global elite thought leader since 2022, and is also a Weinstein International Fellow, serving as Regional Project Director of the Weinstein International Foundation. Tat, can I invite you to the stage? Can I also invite Dr. Székely to take your seat on the stage? Our next panelist is the Honorable Justice Philip Jeyaretnam. Justice Philip Jeyaretnam is the president of the Singapore International Commercial Court. His focus since joining the bench in 2021 has been on complex commercial cases, arbitration law, building and construction, company and trust law. He is also a member of the Judicial Service Commission and the Presidential Council for Minority Rights. Our next panelist, Associate Professor Dorcas Quek Anderson, SMU, Yong Pang Hao School of Law, Singapore Management University. Dorcas has more than 2 decades of experience as a practicing mediator and in dispute resolution research. She is an accredited mediator with the International Mediation Institute and Singapore International Mediation Institute and is currently a mediator with SMC, Singapore International Mediation Center, MOH Holdings, Asian Development Bank, and the Office of Ombudsman for the UN Funds and Programs. Our final panelist, ladies and gentlemen, is Mr. Kevin Lee, Barrister 20 Essex. Kevin? Kevin is a barrister specializing in international commercial disputes and public international law. He has acted as mediation counsel across a number of novel matters, from an interstate mediation of a maritime boundary dispute to several multi-jurisdictional commercial disputes mediated under the auspices of CEDR and SIMC. In addition to his counsel work, Kevin has also been appointed as legal advisor on international dispute settlement by ASEAN for the Southeast Asian States, SAARC, for the South Asian States, and the Council of Europe. And with that, I will hand the time over to Tat. Over to you, please, Tat.
Thank you, Henry. And welcome everyone to the Singapore Mediation Lecture. This year, what I think we want to do for the panel discussion is to involve everyone who's here. And how we are going to do this is principally we are going to unpack what Orsolya has talked about in terms of her speech. There are 4 key elements that we want to unpack. And the way that this is going to happen is, as I mentioned, a theme, and there are 4 themes. We will then do a Mentimeter poll. There will be a question that's posed, and we invite everyone to then pick up your cell phones. And to the question, to a statement that's given, you'll be asked whether you agree or disagree with the statement. And then the panel members will pick up the audience answers, and the discussion will evolve from there. So if there's not as many responses, it might then skew the answer towards a different discussion. So if you have a cell phone, I encourage you to do that. The other thing I should say as a preliminary remark is please do raise your questions. The panel has only 1 hour, but in the event that we can't get to the Q&As, those Q&As, the questions will be picked up and perhaps addressed in the journal. Eventually, an article will be written, as it does every year, on the Singapore Mediation Lecture themes. Well, this would be an appropriate time for me to thank members of the panelists for agreeing to be in this panel. There is a storied history that I have with each panel member, which I do not want to go in detail, but I think suffice to say, I think the longest relationship I've had with any member of the panel is probably Judge. For many years, I think more than 30 years ago, we were young officers trudging in the jungles of Tekong. And that, I think, is when we first met. The next person I knew the longest is Dorcas, where when PDRC was first started in the subordinate courts, as it was then known, we were some of the pioneers, and she certainly was a trailblazer that developed court annex mediations and evolving to the way that mediation is now so entrenched in the courts, both in the state courts as well as in the frame in which litigation lawyers and arbitration lawyers address disputes, looking at mediation as a way to resolve disputes. Kevin and I were together practicing for a short bit before a higher calling called him away to other cases. Good friend, but always spending a lot more time than I think helps him in some other parts of the world. And of course, my newest friend, Orsolya, who one could say is my boss at the DRS and the World Bank. So these are my panel members, and I'm very happy that they've agreed to join me. So with that, what we want to do is to explore the 4 themes, starting with the rule of law, and then going on to discussing themes relating to dialogue, and then moving on to accountability, and then finally, dispute resolution. So those 4 themes. And I will keep my eye on the time so that we can address all 4 themes and poll your reaction to the question, and then have the panel members speak about maybe each of those 4 themes. So maybe with that, we could put up the first question on the Mentimeter for your reaction. As the Mentimeter QR code is being put up, I just wonder if you can see then the first question, which is the question relating to rule of law. Far from advancing the rule of law, mediation can be a weapon for the powerful to erode it. And we want to see what your responses are like. I can't actually see from this angle. Kevin, here, okay,
yes,
great.
You can see it.
Okay, yes and no, right? So there are more people who voted no than yes. That's actually pretty interesting, because before we started this, of course, I asked my panel members what their reaction is to each of these questions, and this seems quite at odds with our own internal poll. Any comments? Dorcas?
Yeah, I see 60 said no. I think one of the struggles we had was whether the question was phrased clearly so that people know what no means and what yes means. Hopefully the other questions won't pose such difficulties, but these seems to suggest that majority think that mediation can be a weapon for the powerful to erode rule of law. Oh, sure. Yeah, so
Other way around.
if you had a wrong answer, it's a chance to rectify it. But people seem to think that. But I will share my views later. But it's a bit surprising to me, but
Yeah.
in a way, perhaps also reflective of the current climate internationally, where we do see that consensual processes, some people can be quite cynical about it, because without perhaps certain checks, maybe they think that mediation being a consensual process can sometimes be wielded by the more powerful to get an outcome that is more advantageous to the powerful compared to the weaker.
And just for the benefit of people polling in, the questions are designed to force you into a yes or no. Obviously, the answer, if one wants to unpack the question, is not a yes or no. One would have to spend a lot of time trying to explain why it should be a qualified yes or maybe a qualified no. But this is a provocative way in which we can then lead to the panel discussion. But that does lead me to a question for you, Judge. And the question refers back to a 2023 keynote address that you made at the launch of the Appropriate Dispute Resolution, the Singapore Way, where you remarked that, and I quote here, mediation in and of itself has only an indirect relationship to justice because it focuses not purely on the rights of the parties, but also on their interests, regardless of their strict legal rights, unquote. But you also warned in that speech that if mediation is unmoored from the legal system, it may advantage the strong over the weak. And so when we look at this poll where majority of the audience seems to say no to the proposition, and in light of your earlier caution and sentiment shared, how do you see the courts, institutions, and mediators working together to ensure that mediation complements rather than compromises the rule of law, particularly in situations where parties are not on equal footing?
Thank you, Todd. Let me start by perhaps offering an explanation for the resounding no to this. And that is, of course, because in Singapore, mediation takes place against the backdrop of an efficient, effective, and relatively affordable legal system. So mediation in Singapore is certainly not unmoored from the legal system, which was the what I was talking about in that lecture. And of course, once you situate mediation within the overall system, it's a very powerful tool, not just for achieving a good result relatively quickly, but also for achieving outcomes that you couldn't achieve in litigation by bringing forward interests of parties into the mix, and indeed achieving more nuanced outcomes as opposed to litigation, which, as we all know, is typically one wins and one loses. So the point that I was making in that lecture was really about situations where there is limited access to justice. Either it's going to take too long to get a result in court, or it is going to be too expensive. And so cautioning about situations like that, because of course, if you are a claimant and you know that you will only be able to get a result in court, say, a decade later, if at all, then your first priority will be to just get something, anything at all, right? And so to settle at a price which is far removed from what you would actually be entitled to under the law.
Yeah.
And so that was the concern that I was addressing. And I thought I should just say one more thing, which is responds to the wonderful lecture we have just heard. And I think what the DRS does, what the World Bank does, is to even go beyond what we've just been talking about, because when the World Bank funds a project, it is, as a condition of the loan, as I understand it, putting in place this mechanism. And so it is actually creating an opportunity for compensation, which would not exist otherwise. And so there we see mediation as part of something very, very positive. It's something that wouldn't happen without it.
Thank you. Panel members, any thoughts on what Judge has just mentioned? So, yeah.
Yes, thank you so much for bridging into the World Bank context, because I actually would like to answer this question the same way. I don't see it as a weapon for the powerful mediation. But of course, that was the perception. That was what was originally thought before the DRS existed, that how would power imbalance be overcome between a powerful government and community members who may not be that well informed of their rights and what they are otherwise entitled to under judicial processes or World Bank standards. So we had to make sure that both the process is designed that way, that this power imbalance is overcome. Mediators identify the needs for potential trainings, which we designed into the process for community members and for government officials as well, so to be able to carry out stakeholder consultations in a more meaningful manner. But also, I think it's very important that how power is seen. So it was really interesting to hear executive agency members speak about, but the community is more powerful. There are hundreds of them. We go there, we are afraid. I don't dare to speak to them. Of course, I bring the police with me because they are so powerful. So how do we see power is also very important in the context of mediation, and we need to understand that in a neutral manner before we address it.
Yeah, and that brings to mind, I think, the definition of power, right? Because in some of the disputes that we see in the World Bank, moving away from disputes between governments and communities, but it may be communities and funded companies, you might find that the companies are unable to get an even keel in the mediation process because the communities are assisted by civil society groups. And sometimes NGOs and civil society groups do offer a very powerful element of advocacy to the process. And I wonder if, Dorcas, you've done some work in that space, training mediators from the Asian Development Bank, and what you see might be some of the trigger points that leads to this imbalance of power.
Power imbalances.
Yeah.
So, yeah, I thought I would just pick up power imbalances as well as something that Judge alluded to in terms of how mediation also advances a substantively just outcome or doesn't. So I thought it'd be useful in terms of a frame to see it, because justice, rule of law can mean different things to different people. So having formally worked in the judiciary, I wrestled a lot with this question. So mediation, justice, rule of law, and our judges have made a lot of speeches on that. So I think definitely want to affirm that at least how the judiciary sees it in Singapore, that I think it's quite clear that they see mediation as one of the options alongside with litigation that you can choose, which can then advance access to justice. But the more thorny question then is, right, supposing that all these options are there. So it's not a situation like, you don't even have an option to go to court quickly and therefore mediation offers you something, otherwise it won't be there. I think the more thorny question is that how to understand the idea of an outcome in the context of mediation.
Yeah.
So there are probably two elements there that sometimes when we talk about whether it advances rule of law or just outcome, one can be you're talking about the actual substance of the agreed outcome, right? Whether it veers a lot away from your entitlement, whether it be international law or whether it's according to the law of the state where you are doing your mediation. So that's one. And then the other is that what's the impact of power imbalances, right? Because the idea of mediation is it assumes that people have autonomy, right, to then advance or ask for what they need. But when it's not full autonomy in the sense that one intimidates or one's more powerful, that's where power can affect. But I just thought I'd like to address briefly, because this the first part, because there's been a lot of writing about that, about justice and mediation. And I thought that in a sense, when we're talking about justice is the outcome, you can't use a yardstick of the rules, so what you're entitled. You can't really positively use a yardstick as what your entitlement is according to the law. And let me explain a little bit, because it's a bit like you're not really bring a light thing to a light thing, or apples to apples, in the sense when you're talking about and you're juxtaposing both processes in terms of the outcome that you get. And I think yesterday, I think Justice Maniam actually gave a story in the CIJRA forum about, I think it was a very apt story. He said when he was a lawyer, he remembers that he was representing a client being sued by his friend.
Yeah.
And it looked like from the legal standpoint, there was no resolution because of the amount being claimed and asked for.
Yes.
But when they went for mediation, it was just so surprising that they could resolve it because they then went to target, address the interest. What the friend wanted acknowledgement of the wrong done, and so there was an apology together with a nominal payment.
Yeah.
So I think that is an example that the justice, in a sense, so some people have written about justice from below in mediation, in the sense that you are not talking about legal entitlements, you are talking about your real concerns.
Mm.
And sometimes your real concerns might correspond with your legal entitlement.
Mm.
Sometimes it might not, because you're maybe more concerned not about the money, but I want you to acknowledge what you've done. You have, then I won't ask for more money. So they might correspond, they might not correspond. So, and I just like to share that sometimes because we think too much, we tend to swing towards two extremes. One extreme is that, okay, it's whatever parties want, so we just leave it to them. But that sometimes diminishes the idea which many legal courts actually bound us to as mediators. Is actually you do have some gatekeeping role in terms of the outcome for very illegal, unconscionable outcomes.
Yeah.
So it does not mean that mediators are totally hands-off in terms of the substantive outcome. But I also like to suggest that substantive outcome, sometimes if it clearly infringes certain norms, we don't say legal norms, can be some norms or international law or some other things. I do think that sometimes mediators have a role. That is my view, in the sense that especially when you have norms that, especially there's no informed consent, that means they are not aware in maybe agreeing to some outcome that this is what I will get in court, right? So that's why you have this whole concept which is quite prominent about mediation or negotiating in the shadow of the law.
Yeah.
So the reality is that a lot of the mediations, at least those convene when there's still a pending case in court, it is in the shadow of the law because you might have legal advice. Uppermost in your concern is what I would get if I go to court. So in a sense, it can't be totally ignored. And if there's still some alarm bells, I feel, if the mediator senses the person does not know. So that's why we say there's no informed consent. You have not been advised. You don't know, actually, you can get, say, maybe 50%. And then on that basis, that premise, you agree to 20%. And so that is an issue, I think, that has to be sometimes talked about more in terms of how do we balance such concerns. Yeah.
Yeah, and I think it's important that I think for all of us to appreciate that sometimes what I do is in the mediation, one looks at the case and we understand, of course, that if one wants to evaluate the case of a mediator to launch into an evaluative form of mediation, you actually examine the merits of parties' respective positions, usually from the perspective of their respective legal case theories. But often nowadays, more often than not now, I explain to the lawyers that perhaps today is a negotiation based strictly on game theory. And when you launch into a discussion on game theory, it has absolutely nothing to do with the merits of the case. It has to do with the psychology of how parties are prepared to land on a number that they can live with. And once they get to that number and they can live with that number, they settle, they move on, and nobody ever revisits the legal merits of the case. So something I think in that piece that segues to those thoughts that I think both of you have mentioned. It is also a useful point, I think, for us to move into the... Yes, Kevin.
I thought I'd share an interesting reflection on that. If we switch our hats, it's like sovereign litigation and connecting both what Dorcas mentioned about power imbalances as well as whether mediation can be a tool. I think actually in some of the sovereign litigation matters that I've been on, actually it's the litigation system that has power imbalances that may not otherwise be visible in the usual private context. So that actually makes mediation much more suitable. So just to give you an example, one is the repeat player problem, right? When private parties are in dispute, you often have different parties for different disputes. But when you face a sovereign sort of piece of litigation, what we don't often see in this country, because there isn't much of it, but in bigger jurisdictions like the US, like the UK, each sovereign can be facing upwards of 20, 30 pieces of litigation, so long as it falls within the commercial exceptions to immunity. What that means is that you could have very good merits as a sovereign in a case, but because of discovery proceedings that are mandatory in litigation, you end up suffering the sort of pain of litigation, of potentially compromising issues of national security, sensitivity, in discovery that could be dragged through the litigation system that you otherwise wouldn't want to happen. So in those instances, I often try and advise or try to get parties to say, hey, can we go to mediation instead? And oddly, we don't want a facilitative mediation. We want an evaluative mediation, just without the pressures of game tactics and game theory, like you mentioned, that we otherwise have to suffer in the mandatory discovery process of litigation across multiple fronts. So I think that's an interesting reflection that makes you sort of switch hats and think about how do traditionalist principles of litigation actually end up causing a power imbalance in favor of the weaker party in litigation that could otherwise tend towards a better process of mediation.
Yeah. Thanks for that. But we are going on to the second Mentimeter question, which would be polled, I think, right now. And the question is, confidentiality within mediation undermines the mediator's accountability to the disputants and the public. Do you agree? So we'll wait a moment for audience to poll their answers. So far, the noes have it. Interesting, as the answers come in again, I look at my panel members and say that this is very unrepresentative of the voting we had internally. Any thoughts from anyone on why do you think it's going this direction?
Yeah, because maybe the public was missed at the end. But
I think we're debating which words people will focus on.
So it's interesting, right? Because the key takeaway from the last two slides for me is that actually, as a system in Singapore, we've developed a lot of public trust for mediation.
Yes.
Yeah.
And perhaps in our internal voting, we had to discuss what were the keywords in the statement, right? And some of us focused on the words accountability to the public. And that triggered us to react and respond in a certain way. But on this question, perhaps I could pose a question to you, Kevin. And this question relates to the question of confidentiality, but tapping on your experience in investigative dispute settlements where questions of legitimacy, transparency, public interest are especially sharp, right, as you explained. How do you view the tension between confidentiality, which is, of course, as we all agree, a cornerstone of mediation, and the need for accountability in the processes involving public entities or state actors?
So to me, one of the reasons why I feel like I would agree with this if we kept the thesis statement to private parties, but here there is the element of and the public. And I feel like the sort of assessment changes when one starts to consider matters of public interest. So there are two sort of tensions in my mind that I think require some qualified consideration of the thesis. The first is the whole exclusionary process of mediation. It is not just confidential, it is private. And if I could give you an example, and we were just talking about this before the break, from a documentary called The Tribunal, and it was about a Canadian mining company and its investor-state arbitration against Ecuador. And part of the issue there, and the documentary focuses on this, is the inadequacies of arbitration. You have the Canadian mining company that was granted licenses to mine in Ecuador, and as a result of that, executing its mining license legally had displaced domestic communities outside of the area in which they were being mined, had caused immense environmental harm in those areas as well. Now, what happens is that the state then terminates the license in order to eradicate that sort of harm and to try and move communities back in, only to be met with a claimant, mining company launching investment treaty arbitration against Ecuador and winning, right? Because theoretically, there is a legal right to mine, and at the same time, it had been unlawfully terminated prematurely. And what the dissatisfaction is that at the arbitration level, you can account for the views of both parties, but there are very limited areas in which victims can sort of appear in the arbitration process. These days, there's an amicus process, but it requires usually the consent of both parties as well. And you have a dissatisfactory outcome where the award grants money to the company that was exercising its mining license, but to a great detriment to the public, and that being reflected maybe only as, let's say, a fallback value that you credit, in the result of the award. but nothing actually going to the victims. So I feel like that to me is one context in which I think mediation suffers maybe from some deficiencies of accountability as well, right? We perhaps may need to think about more flexible ways to involve victims, victim impact statements, the ability for people to participate in proceedings that actually contribute to the ultimate justice of the issue at hand. Now, in the ICJ, there's something called the monetary gold principle, which is if the subject matter is rightfully sort of affecting the interests of a third party, the court actually cannot exercise jurisdiction over the issue that is, over a claim started between the two parties without the third party. And some of that justice considerations, I feel, does lend weight actually to considering how we can make mediation more flexible. Just as a very quick point, I know I've talked for a long time now, but the second is sort of publicity relating to outcomes, right? And one of the key issues there is that if, for example, in one of the sovereign mediations that I did, maritime boundary delimitation grossly affects, multiple states within the area on how, let's say vessels should be run, etc., public interest. If you end up having a mediated settlement that isn't public, there is actually some thinking there, right? That there are considerations about the public needing to know, etc., accounting to public justice, which is why many times, now this may not be apparent to some of you, but in sovereign litigation where we do have a settlement, we think very hard about actually making the settlement public. Because we want there to be a message that no, nothing under the table was being done. This is all in aid of public justice.
Right.
Yeah, so my two reflections there. Yeah.
Very good. Yeah, Orsolya?
Yeah, when we were building the DRS, this was actually one of the major critics from the public, from CSOs. If you do have confidential agreements, how do we make sure that the agreement is accountable, you are accountable, and that the bank is accountable for whatever harm they were doing, and the borrower altogether. So I think it's a balance to play, that you do have processes that make sure that whatever happens is accountable. So for example, in our case, we had to build in that in my role, I would be overseeing agreements which happen and have to make sure that they are not illegal, that they actually meet the bank standards and they are in line with whatever the bank would otherwise aspire to achieve, also in terms of its commitments to the standards. But then at the same time, of course, it's about making something public, even if the agreement is confidential. So we had to develop that my notice to the board, which in itself, a public document, does include enough information of what happened, but not too much information protecting confidentiality. So it's this balance we need to play, but I look at it as also an opportunity to learn, because if we do make some elements public in terms of what happened, especially in the public sector, that's an opportunity to learn for other countries as well, and peer governments. So I think in some ways it's a challenge, yes. I don't think anyone wants to hide anything, but it's also extremely important that the safe space is protected and that confidentiality is protected for the discussions to happen.
I want to press the panel members to maybe answer a slightly nuanced question than the one we posed. And the question would be, I think if I ask the question, do you think mediators are accountable to the disputants? I think the answer would be unanimous. But let me pose the question the other way, which is, are mediators, in your view, accountable to the public? And I'll start from Kevin, you, and then we'll work our way this way. Kevin?
I think insofar as, this is such a tricky question. Insofar as there might be public interest issues, I feel like innately the answer is yes, right? Because to do complete justice, you inevitably have to take into account views of the public if they're being affected. And many times, I think, if you don't involve third parties that may otherwise be affected, the dispute between, shall we say, one applicant and respondent is intractable to begin with. And in fact, we've seen this in some of the work we've done together, where you have, let's say upwards of 4 parties, and only 2 of them want to come to the mediating table. What then do you do with the remainder if the liability is joint and several? It causes all sorts of complications that way as well. Yeah. So to me, you have to take into account the sort of third-party interest if it's on the table. Yeah.
Yeah, and you say in public sector disputes, but let's sort of paint you further into a corner and say in private disputes, where clearly there are only a limited number of parties, say two-party dispute, the typical one, would in that case a mediator be accountable to the wider audience in the public? I mean, if you call them audience at all, would the answer be a yes or no?
I think no.
Okay.
With the asterisk, which is that I don't think, for example, you can try and mediate away criminal behavior.
Okay.
Yes.
I think that there's a big asterisk there.
Okay, well,
Yeah.
that's a great answer. Dorcas?
Yeah, 2 points. I think first, you said whether the mediator is accountable to the public, right?
Yes.
I take the view that if the mediator is operating in the confines of some institution, it raises a different issue, right? So we're not talking about the agreement to mediate between the mediator and the parties. Mediator and the reality, the mediator somehow represents optics-wise the institution, right? Whether it's be a center or whether it's context of the courts. So I think the broader way to look at it is that there is accountability in the sense that you want to maintain public confidence optics-wise, right? And I think all of us can see that sometimes you just talk to friends, sometimes people just voluntarily come out and say, you're a mediator. Let me tell you my experience in mediation. I went here and there. And I don't want to tell, but then they tell. But I think it underscores the reality is that public confidence, even though it's high, can in one moment be declined just by a bad experience.
Sure.
So I think accountability in the sense that to maintain that confidence in the process and the public, and you will have impact, like Dr. Orsolya pointed out, whether people want to use it in the future, whether they are confident that the outcome would still be something that they are confident in. But I think the way to do it is not, there might directly pierce confidentiality in the sense that have a lot of exceptions and then let people know what's going on, because as Dr. Orsolya pointed out and Kevin, there's that tension there, right? And the attraction to mediation is precisely the confidentiality. So once there's so many exceptions, you really undermine the attraction. But I think the way is, and this has been written by like say Nancy Wells, she writes a lot about procedural fairness, accountability. She argues that maybe institutions, some things can be aggregated, right? So if we say that it advances access to justice, give the people data, aggregate data, which does not necessarily breach confidentiality, but you are making a case, you're trying not to, because even though things are done in a good setting, it's just people tend to always be suspicious if you don't say anything, right? But if you put data out there and so that it assures people what's being done aggregate-wise, I think it can make a great difference. And so my point is that it does. And I just want to have a shout out, one small point, to say that there is some element of public. So, I mean, there's this International Mediation Institute ethics committee, which you and I are part of. And we also have Ivana, who is the executive director of IMI here. And I want to say, we had a lot of conversations on what principles should govern mediation, right? And I just want to highlight one aspect that I think is quite unique in the draft code, which is now open for public consultation, a principle of professional integrity. Yeah. So I think it says that professional integrity requires a mediator to act within the confines of the mediator's role and congruent with the mediation process. And it highlighted 4 components in your decision making, and exercise your professional discretion, in the consideration of the appropriateness of the case or the mediation, and I think more importantly, this one, the prevention of process abuse or substantial defects in the process. And some of these defects have been defined like the use of conduct that exhibits bad faith, inconsistent with the purpose of the mediation, undue pressure, exploitation, duress, or if it seems the agreement to severely jeopardize the standing of and public trust in mediation.
Yes.
Right. So, for instance, sometimes the settlement terms might not be fully confidential. Right. Maybe for a media release, it might have to say something. So, how would people react, not knowing what happened, the full context of mediation? So, it might be something that I think in this day or age, you might have to be aware of that, because even people are confidential, sometimes they just start, the way they just start talking, it leaks out. And I think I just want to say that from a perspective of mediator, confidentiality is like, antithetical to, judiciary is open justice. So the reality, I just want to be honest, is that sometimes when we do things in confidential, there are many things we can do wrongly, which we are not even aware of.
Right.
So, and if no one tells us, we'll continue to do it.
Yes.
So I think it's just natural human nature. So I think it's important, therefore, that there's some kind of feedback mechanism. Maybe parties give feedback, or then you get to know, or at least the institution has some oversight. So I personally believe accountability is very important to the public.
Thank you. Judge and then Orsolya, right?
Okay. Short answer is, of course, confidentiality is contrary to accountability,
Yes.
right? But it's precisely because of confidentiality that many parties will choose mediation, because the party that is perhaps the defendant, let's say, is seeking to avoid public scrutiny. It's an incentive to settle quietly in mediation. So, of course, these two things are in tension, but you can't just throw out confidentiality because then mediation will become substantially less popular.
Yes.
And wouldn't have that incentive of avoiding, public glare. I thought it might be worth just mentioning one other situation which is highlighted and illustrated, and I think it's not been covered yet, by the case of PNID in Nigeria, which is where an arbitration award was obtained against the Nigerian government in circumstances where there was corruption, and including corruption of the government's defense team. And so you had this flow of information going from the defense team to the claimant's team, and you had an arbitration award which was actually divorced from the real facts of the case, and it was set aside in the London Commercial Court. And it was only in court that you had the scrutiny that enabled something like that to be caught out and dealt with. And a similar issue, no doubt, can arise in mediation, where the mediator is in effect being made use of. And so that's where one really has to think about what are the mediator's duties, ethical duties, not just to the immediate parties in front of them, but to the wider cause of justice and indeed the public.
Yes, thank you. Orsolya?
Yeah, I would like to mention maybe two things. I would like to mention the opposite. Confidentiality is an element that is preventing you probably also from being accountable. So what if there are accusations out there against the mediator that you have done something this or that way, which is not true, but you can't actually defend it, or you can't protect the accountability of the process or integrity of the process, not to mention the mediator himself, because of the confidentiality. So I think that's another layer of challenge that many mediators struggle with, not to mention then how to present the results or the outcomes or the good lessons learned from the process. But then also, I think I noticed in the context of the World Bank and the public sector, that very often they want this public knowledge out there, not only because of accountability in the sense of strictly of the process itself, but because they are concerned how the agreement is going to be implemented. So if the outcomes of the agreements are not known, how can the public, or how can CSOs, or how can outside actors make sure that it's actually going to happen?
Yes.
And I think it's a very valid question. That's why we built in monitoring into the process, because we wanted to make sure that actually it does happen, but also that at the end we can report on the outcomes of the monitoring, at least once the agreement is implemented. And maybe that's another opportunity to go back to the parties and ask them, are you now okay with publishing the agreement itself? Because then it would be an opportunity to learn it.
Right. Thank you. I mean, I think in the Singapore space, at least, all of us who live here and practice mediation here know of at least one case where the mediator's conduct was scrutinized by the High Court. And that case, of course, involved a party who settled a case and subsequently filed an application to set aside the mediated settlement agreement. I know about that case because if you read the case, the co-mediators in that case was Dr. Josius and myself. And it appeared the case went before Justice Tan Seong Tai, who was asked to examine whether the mediators had applied undue pressure on a party that forced her to sign a settlement agreement. And he said, well, all these things that you are complaining about speaks of reality testing, which is exactly what the mediators are supposed to do. But it does speak of that degree of accountability that when you practice, and even in your private caucus, those things that are secret and private, sometimes they could explode that way. And as a trained and experienced mediator, you better be sure that you're doing the right thing.
Could I have a quick comment just
Yes, sure.
on both your points? So I think just to add to your point and confidentiality, I just thought it's quite timely to say that, yeah, there are checks. Yeah, so for example, when there's disciplinary action against a mediator, I believe I was in this conversation with Mr. Kevin Quack, SMC. He was telling me that, they have to do a lot of work sometimes dealing with these things. So they actually have to deal with complaints, and then some mechanism is activated.
Yes.
And of course, we know in Singapore, the Singapore International Mediation Institute, SIMI,
yes,
right, chaired by Prof. Jolie.
Yes.
So that actually all who are SIMI certified, theoretically, people can complain against you, and then the disciplinary mechanism is activated.
Yeah.
And I think I was talking to Chen Yang, also the Law Society Mediation Scheme. They're also looking at ways how there can be accountability. And once there's accountability, according to the law, we know there are those exceptions to confidentiality. And to link it back to the Singapore Convention, of course, we know when there's serious breach of mediation standards,
yes,
that can be a ground for non-enforcement. This is a ground that's also repeated in Section 12 of our Mediation Act, in the sense that the court can refuse to record it as a judgment if there are certain well-known contractual grounds for vitiation, including like breach of policy, public policy.
Right. Okay, on to our next theme, accountability and dialogue. The question which audiences are asked to answer, rather than enabling genuine dialogue, mediation mechanisms often exclude those most affected. Do you agree? So the answers that's streaming in looks a lot more consistent with what we polled internally. I'm actually interested in the 4 audience members who says yes.
They're voting confidentially,
Yeah. But maybe on that note, let me throw the question to Dorcas in this case, right? You did some research and you wrote a paper in 2016 where you observed that the ADR processes, including mediation, are increasingly used to, in your words, increase access to justice and to mitigate the limitations of the formal adjudicatory system, offering a more informal justice that is, in your words, more empowering and participatory, while also less alienating and costly. So maybe speaking on your view, what features or safeguards do you think must be present to ensure that mediation genuinely includes and empowers all the participants, including those who might be less vocal, less resourced, or perhaps more vulnerable to the dispute?
Yeah, I think Dr. Soya, you alluded a little bit to that when you're saying that sometimes the preparation takes a long while, right? Then even identifying who are the people we talk to. And yeah, so I think if we look at the mediation, I think in the private context, I think the same principles do apply across the board. And one way to make this really real is, I think it struck me once just prior to the mediation. And I deal with some cases where there are a lot of repeat players. That means they might know how mediation works. They have been there a few times, but then you have one first-time player who has no idea about mediation, how it works, no idea about negotiation. So very simple, sometimes not be obvious, including like many times, if you don't know how negotiation works, you might give your best offer, right? The first round of offers you give the best and no room to move anymore. And then you can't move anymore, then the other side say, why are you coming here in bad faith? Right? And then it results in a lot more misunderstandings. So some of the sources of imbalance may be just simply you don't even know how this process works. You don't know the norms of negotiation. And I think this was brought home to me when, before one mediation, I already talked to each side prior mediation. But when I talked to this person, I could sense he's a client. He was very, very nervous. So I just talked to him before we started the mediation and said, are you doing okay? Then he said something, oh, you know what's going on. I don't know what's going on. I mean, he was referring to even his own advisor, legal advisor. And I realized sometimes that creates a sense of alienation that I don't even realize until I really actively put myself in the shoes of the person. So even like that, I think so experienced mediators would all know that sometimes they even look at the room setting, and just assuring them also what's going to happen, just telling them about the process. So I think simple things that if we bring it to just like a simple mediation, just bilateral, two persons, some checks that possibly could be there. I think probably first putting ourselves actively in the person's shoes, trying to understand this person coming to this process, this environment, how that person would feel, and both sides, not to assume that the typically so-called weaker party, like you mentioned, actually is weak. Sometimes they might be the stronger one, and the one that looks strong is actually very coward because they know they wield the power to ruin the company. So, and then the other thing is, which I know a lot of mediation friends do, you involve them in designing the process, in the sense of talking to them. There might be a fixed process, but trying to know their needs. For instance, someone might need frequent breaks, as simple as that, because they just can't compose their emotions. The other one is, and some of these were actually, I thought there was one report actually written by, I think the compliance CAO, Compliance Advisor Ombudsman, they actually had a report and they encourage various ways to do that, like being culturally appropriate.
Yes.
So not everyone might be comfortable, we speak all around a table. That might actually have an alienating effect, right? Or going to where you go. So I remember talking to Linda, our good friend who a mediator. She mentioned that even deciding on the venue, they decided to use a certain party's religious institution's premises as the venue for mediation. Because when they went to try it earlier mediation somewhere else, some of the key spokesperson, many of them were not present. And they also don't, I think it also has an effect. So things like that, I think once we put ourselves in a person's shoes, have those conversations, involve them, then I think some of these power imbalances can be preempted.
Actually, I want to turn to you, Orsolya, because the World Bank, DRS, has done a lot of work into ensuring that effective dialogue takes place and ensuring that the mediation mechanisms do not exclude those who are most affected. Maybe speak a bit about what's been done to unpack that here.
Multi-layer efforts to do that. Partly because a compliance investigation starts out with any two requesters submitting a complaint, which is a very powerful way to approach a mechanism, and usually assisted by civil society advocacy actors. But when it comes to dispute resolution, of course, you have to pay attention to all project-affected people who are affected by that potential harm. So how do you shift from two loud voices to having everyone represented, hundreds, thousands of people in a process, and not to delay the process by having so many? So we invested a number of efforts to doing that, besides the fact that we do trainings for communities and project-affected people within the process, but detached from the mediation team. So it's very important they should be allowed to express their questions and their learnings outside the mediation process, then they don't feel weakened in their positions when they do the mediation and the discussions, but also to help them to formulate maybe their true representative structures, because what may be an advocacy representative structure may not be the representative structure in mediation. So I think it's very important to recognize that whatever is given on a front face may not be genuine. And that representative structure, by the way, may change. So those who walk through the mediation, start of the mediation, may not be the one who are capable of finalizing an agreement. So I think it's important to pay attention to these nuances all along in the process as to how we make sure. Then we also do trainings for CSOs, which is another very important conclusion we drew. If the people cannot be assisted by qualified, equipped CSOs, then in doing mediation, not advocacy, which is a different role, then it makes our task a lot more difficult because, as you have mentioned, Judge, it may not be that they get at the end what's right or what's according to law, but what they actually want. And formulating those things can very much detach from a CSO who is more interested in promoting a rights-based approach, to trying to basically have a more generic approach to a given case. And I think it's also important to pay attention really to the most vulnerable, who are invisible. So those who cannot access a site because of disability, those who are excluded from the society because they are considered non-existent, non-actors, and we know that this unfortunately still exists, or those who simply because of traditional decision-making structures are not involved in decision-making. And very often women are, of course, part of this group. So we have to make sure that when we enter a dispute resolution process, we don't take for granted what's given.
Yeah, I think that's all very useful. I mean, I think one of the learnings that I've had in the maybe by now almost 8 years I've been involved in the CAO and the World Bank DRS is how much effort goes into for the media to develop a rapport with the CSOs, with the NGOs. That trust building is not just with the parties, but also with the extraneous parties, the parties who represent interest groups, and building capacity. Often we call it capacity building from all fronts. But that helps to create that rapport and ensure that the mechanisms do not exclude those most affected. But now we move into our last point, and very mindful of time because after this, of course, is lunch, so people get hungry, and I'm sure that the panel wants to conclude before we have upset people in the room. But this is the fourth question, which has now been polled. In disputes involving governments, corporations, communities, true neutrality by mediators is impossible.
You like asking provocative questions.
Well, to be fair, a lot of these questions were crafted with the assistance of one of us in the team. Okay, well, at the moment it looks fairly even, I think, and so I think we can take those as evolving in that direction. So maybe this question to Orsolya, right, that you spoke today about mediation as the foundational mechanism of the development accountability, one that cultivates dialogue, ensures just outcomes, empowers communities. And I think what perhaps you can help us understand a bit better is that given this inherent tensions and power imbalances in such disputes, where state interests often overshadow community voices, what institutional designs, mediators, attributes, or procedural safeguards do you think are essential to approaching to at least allowing genuine neutrality or perhaps sufficient procedural impartiality in development-related mediations?
I think it starts out from the beginning. So when we designed the dispute resolution service, this was essential. Neutrality of a mediator is key to developing trust by all sides. And how you make sure that this is a given is from the start. So for example, we don't choose mediators for the process. We offer mediators based on their expertise, but it has to be the parties who choose them. And it did happen in one case that one of the sides said, well, no, this is not the right mediator. It turned out in the discussions, he was school friends in school with the president. So, I mean, we can have mishaps in proposing mediators, but that's why it's so powerful that the parties can actually say, this is the person who we trust to work with. So that's from the start. Then when you enter a process, of course, you make sure that there are procedural guarantees, that the mediator is not even, in our case, doing any evaluation. So whether or not what's the outcome of a compliance investigation, not our task to speak for and not the mediator's task to explain. There can be questions asked directly from the inspection panel in our case, but also there can be these things explained by management if they are part of the process as observers as to what a management action plan at the outcome of investigation can do and cannot do. But it's not for us to evaluate and not for us or for the mediator to say what you would end up with at the end of another kind of process. And then if you truly want to have neutrality, that doesn't mean you are blind to power imbalance. So I think it's really important to make sure that you are not non-neutral only because you notice. You have to propose something that brings the discussions to an equal. So you can then suggest, should we have a capacity training? Should we have a community discussion separately? Should we make sure that you are not meeting directly if you're not ready to do so? Or can we create a safer space where you feel comfortable to have the discussions? All these elements and questions has to be the role of the mediator to make sure that is neutrally approaching that there should be a balance in the discussions. So I think it's, again, important to understand the words which we use, what neutrality means. And neutrality means that you are not driving out of self-interest the process, nor accepting anything that promotes you in any way to be advantageous, but also you are not taking sides in the dispute, and you also accept if there is no agreement. Which is a very important element of neutrality. We are not doing this to promote an agreement.
Very good. So I see 3 minutes left. And so first of all, thank you to all the audience for having polled your answers. I think they've been very rich answers. 35 to 34 very much is in line with maybe what we were suggesting at the outcome. But to others who have actually also raised questions, I'm sure that will be picked up by Dorcas and team, maybe when you think about what materials might be useful for the article that will be written. But it leaves me now to raise that last question for each individual panel member. And this is often what we do, right? Casting an eye on the future. And the question I have for each of you to perhaps provide your final words today is this: what is one insight, challenge, or imperative that you believe the mediation community must take seriously if mediation is to remain a credible and constructive force in advancing justice and the rule of law over the next decade? And we'll take this in this order, right? Kevin, Dorcas, Orsolya, and of course, Judge always has the last word.
Originally, I'd written down one answer for this question, but I think I'm going to change it. Originally, I'd written down cross-cultural sort of expectations because I think we're only going to get more globalized. But I think maybe a more nuanced idea is that as we get more globalized, actually the nub of the issue is that more and more public interest matters are more likely to be amenable to mediation going forward. And if I trace the sort of history in the arbitration space, was it about 12 or 13 years ago that the PCA started developing optional rules for some of these more public interest matters, like investor-state arbitration, and then environmental harm, and then so on and so forth. I just wondered if maybe that's some initiative that we can think about. Optional rules for mediation of public interest type issues, and of course that might further break down into sub-rules and all that. But I think, to my knowledge at least, currently it's either public interest typically in a formal organization where that's sort of dispute resolution being done. But if not, all the available rules are private in nature and don't often cater for some of these public interest aspects. So I'll leave that with you.
Okay. Dorcas.
I thought what Dr. Orsolya mentioned resonated with me, the idea of humility. And in the sense that I think that continual learning from both our successes as well as our failures will actually keep us, engaging in such important discussions. Yeah. So I think if we're at a stage where, for example, there is a lot of awareness of mediation skills, it's a chance and an opportunity to actually go deep, to reflect very deeply on and talk to one another about experiences, And on difficult issues like this, for example, did I manage power imbalances? Could I design it better so that really we deliver on the ground on the promise of mediation really advancing access to justice?
Yes. Thank you, Dorcas. Sue?
I would say balancing cross-disciplinary learning. So these days it's very easy to get information. We all tend to know something about something. And I think it's really necessary because we need to be aware of the larger context, but also learn from each other. I did go back to study quite late in my years because I thought I realized literally the same thing we are talking about in the public sector and the private sector is just different language.
Yes.
So we need to be able to understand each other, to be able to learn from each other. But at the same time, I think it's extremely important not to dilute the expertise that's out there. And I think that's my bigger concern when I look at, for example, just the future of the World Bank, where they are discussing potential merger between the two accountability mechanisms, the private and the public sector. Yes. There lies expertise, which is very specific in the public sector. And I would not want to dilute that because it then can really just flip the success of the process if you do that. So I would like to encourage the future ahead. It's good to keep a balance of these both.
Yes. Thank you, Zoya. George?
Well, I think over the next 10, 15 years, we're going to see more and more use of technology. So the challenge that I foresee is really how do we avoid getting too distracted by technology, too drawn into it? Because at the heart of every dispute, it's a human drama. Yes. And the best mediators are fully attentive to all of that and to finding a solution that works for humans.
Yes. Excellent. So on that note, I first of all want to thank all of you for your time and for all your wisdom. And can we all give a round of applause to the panel members? Thank you. Thank you. Thanks a lot, John.
Ladies and gentlemen, another round of applause for our moderator and panelists for that very insightful and engaging discussion. May I ask our panelists to please remain on stage? At this point, please allow me to call upon Tad, Managing Partner of Aequitas Law LLP, sponsor of the Singapore Mediation Lecture, to present a token of our appreciation to Dr. Orsolya. The gift is created in collaboration with Social Gifting SG. It is a picture of the Vanda Miss Joachim made with Hamas beads. The Vanda Miss Joachim is the national flower of Singapore, depicting strength and resilience. The gift is crafted by Vince Tan Chien Yong, a young man with autism who enjoys diamond art. Not only is this a way for Vince to express his creativity, but it is also a means to earning a dignified livelihood. Thank you, Dr. Orsolya and Tad. May I call upon the Chief Executive of SMC, Mr. Kevin Quack, to come onto stage, please, for a group photograph.